A racketeering trial has given prosecutors an ultimatum. Turn over all your evidence by the end of the week, or there may be a possible mistrial.
Court Judge Paige Whittaker made it clear today the state is operating on thin ice. She has repeatedly warned prosecutors that they need to get their act together.
Now, for the first time, we're getting another expert.
Okay.
Never gave us this information before.
Young Thug's attorney Brian Steele is once again crying foul and accusing prosecutors of not following court rules when it comes to sharing evidence in the high-profile racketeering case. The state pushed back on the allegations by the rapper's attorney, whose real name is Jeffrey Williams.
To say it's bad faith would mean that we held it back for, that's still not the only definition of bad faith, but we did not. We did not hold it back for any, we did not intentionally keep it from them.
Attorneys for the other 5 defendants quickly chimed in, saying former Chief Superior Court Judge Earl Glanville, who was removed from the case, had already admonished the state for the very same practices during the 19-month trial.
Counsel for the defendants are saying, this is the first time I've seen this document, or we haven't gotten this document, it hasn't been provided in discovery, or it's a supplementation of the original document you gave them, meaning that they got it on that date, but instead of the document being 15 pages, it's 45 because it's complete. So that's why I'm saying that it causes them a little bit of anxiousness in terms of trying to be prepared. So, and it'll just further validate or verify, okay, we gave you everything, and it lessens the amount of time I got to spend resolving these particular issues. Like I said, you all are more than capable, and I'll give you the time and effort, but it needs to be better presented and packaged.
So, Your Honor, we can do that, and with respect to the exhibits or evidence, I don't anticipate that we will be getting premature objections, or we had the opportunity to lay a foundation. I could foresee us saying that we're going to introduce 12 exhibits for Act 29 and the defense objecting to it as, hearsay, foundational or something before we've even had an opportunity.
Well, I'm going to require them to put it in writing. But if you do this now, they'll be able to look at it, and they'll be able to determine, A, do I have all the universal documents I need? And then 2, what are the objections on it? Because I can't ferret them out, and I don't think it's fair to the jury or anybody else for us to be sitting here while I elect a district attorney, tried a gazillion cases in front of me. She turned over an entire file to the defendant, and her mantra was, if you can beat me with my file, then you deserve to win. Or if you can't, well, I deserve to lose. At this point in time, turn over everything. There should be no surprises at this point in time with identifying evidence and everything else that goes along with it. So what I'm going to do is 2 things. I want you to catalog these particular. I want you to, for each act and ban that you're going to present, I'd like you to add the evidence you're going to call. I want you to, because
exhibits we intend to.
I want you to add the exhibits you're going to present to this particular spreadsheet. Will that suffice, Mr. Weinstein?
Thank you.
And also, I'm not going to do it anymore. The remedy at this point in time, I think for any appellate, or I could exclude it, and abuse of discretion is my grading mark stick. So at this point in time, if you want to make sure that you get all your evidence, at least in the sense that it is looked at or ruled upon by this court, they need to make sure that they have all of it so they can go ahead and do that. Now, you got other stuff you need.
By tomorrow, then that's what we do. But Your Honor, we'd ask that we not be required to go through and, with respect to all of the acts.
Ms.love, you must act like I was never a trial advocate. I know you all have this stuff together already, and if you don't, I'd be highly shocked. You probably have all this stuff together already. So just put it on paper and give it out so we can go ahead and go forward. It is not giving your trial strategy. The facts are what the facts are.
And how many times can you say, oops? How many times can you repeatedly, systematically make the same mistake as an experienced litigator?
By Wednesday afternoon, the third judge to preside over the drug and racketeering trial appeared to give prosecutors a break.
You better make sure you have got all your ducks in a row and you have shared those ducks and ducklings with the defense.
Now, Judge Whittaker finally concluded that prosecutors did not act in bad faith, but rather have been swamped with evidence in the longest.
It's caught in the crossfire.